Thank you, Dharani. That was a feast to our ears. Before we introduce the guest speaker, I would like to request our Dean to present the sapling to our guest. It is with great pride and privilege that I introduce to you Justice Shri Koratagere Narasimhamurthy Phaneendra, Upalokayukta, State of Karnataka, former judge at the High Court of Karnataka. Born to Srimati K.N. Sunandamma and Shri K.R. Narasimhamurthy in an agricultural family at Koratagere, Tumkur district, Sir pursued his early education in government schools before graduating with a Bachelor of Science from the Government Science College, Tumkur. Sir's journey in law began at Vidyodaya Law College, Tumkur, where he earned his law degree. In 1985, Justice Phaneendra was enrolled as an advocate with the Karnataka State Bar Council, beginning his legal career under the mentorship of Shri M.S. Rajendra Prasad and later with Shri Subramanya Swamy, a notable freedom fighter and advocate. His practice encompassed civil, criminal and miscellaneous law until he transitioned into academia as a part-time assistant professor at Vidyodaya Law College from 1988 to 1998. Sir's judicial career commenced when he joined the judiciary as a select district judge on June 17, 1998. Over the next several years, Sir served with distinction as a district and sessions judge in various locations, including Bangalore, from 1998 to 2000, Shimoga from 2002 to 2005, Udupi from 2005 to 2009, and Haveri from 2009 to July 2009. In July 2009, Sir took on the role of Secretary to the Honorable Chief Justice of the High Court of Karnataka for a brief period before becoming the District Judge and Director of the Bangalore Mediation Center from 2009 going on until 2012. Justice Phaneendra further contributed to the Government of Karnataka as Principal Secretary of Law, Justice and Human Rights from February 2012 to 2013. He then served as the Principal District and Sessions Judge in Belgaum. His elevation to the High Court of Karnataka as a judge happened on October 24, 2013, marking a significant milestone in his judicial career. Throughout his tenure, Justice Phaneendra has been actively involved in educational initiatives. Sir has participated in numerous seminars and conferences as resource person and regularly contributed to the training of judicial officers and public prosecutors at the Karnataka Judicial Academy. He was honored with the Karnataka State Award in 2009 for his contributions to writing judgments in Kannada. After retiring from his position as a High Court judge on May 19, 2020, Sir assumed office as the Honorable Upalokayukta on March 29, 2022. Justice Phaneendra's extensive service record reflects his unwavering commitment to justice and legal education, making him a respected figure in both judicial and academic circles. We are truly honored to have you here, sir. Please join me in extending a warm welcome to Honorable Mr. Justice K.M. Phaneendra, Upalokayukta of State of Karnataka. Sir, the stage is yours.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. Good morning you all. Honorable Shri T.R. Subramanya, Director of CMRU institutions. Learned faculty members of the institution. My dear students of law. First of all, I am very thankful to Shri T.R. Subramanya, for having invited me to this institution to share a few of my thoughts with reference to the subject which I have selected. T.R. Subramanya is known to me since long. When he was Vice Chancellor of Law University at Harvard and Hon'ble. I must say that he is not only a person but he himself is an institution. His rich experience as a professor, experience as a jurist, his expositions on various subjects like administrative law and international law and constitutional law, which really enlightened the not only judicial field but also everywhere where the persons are interested to know about the legal system of our country. I am also fond of reading his articles and also looking at his discourses on legal aspects. Thank you very much, sir, for having invited me to your institution. I think this is the fourth time I am visiting this institution. On two occasions I visited as a judge for a moot court competition, and on third occasion like this a seminar was conducted, I participated. This is the fourth time I am visiting. The subject which is taken up by me or allotted to me after discussion with T.R. Subramanya is very much and absolutely necessary, particularly to the law students according to me. The administration or a public administration, everybody should know how the governments administer the people of our country. What are the role of the governments, or the three segments of the Constitution of India, and what is our role towards this public administration. One should know particularly law students, because we say that wherever air passes or water passes or anything passes, it is in accordance with law only. We have laws with reference to air, laws with regards to water, what law regard to environment. So various aspects, whatever we find in the universe, we try to control that also by way of implementing or introducing a legislation to that effect. Therefore, wherever law goes, the advocate is behind that law. The law students also recognized as the future of our country, future of our legal system. Therefore, according to me, we must enlighten ourselves with regard to this public administration. So then what is meant by this public administration? How the public administration takes place? Public means not only the citizens of the country, but also every person who delve a particular country, he became the public of that particular country or particular area or particular nation, or whatever you call it. So administer means, it is a Latin word. Ad means affairs, minister means manage. That means manage the affairs of the public. So how to manage the affairs of the public? What is required to a person or a citizen or a public who lives in a nation? What is the requirement? For that purpose, what we require from the administration. So that's why we have to know what is the affair of a public to manage it. So we know three important aspects to a person to live happily or a dignified life in a nation. I take this opportunity to start with the words said by Sri T.R. Subramanya in one of his legal discourses. I call them as discourses. Normally we don't use the word discourse so far as these lectures and other things are concerned. We coin that word with some saints who they give their discourses to the public at large. It is attached to saints, normally discourses. But I call them as discourses because they are so near to the people. In one lecture or discourse, he said that Mahatma Gandhi ji had two dreams. One is liberation of India. During his lifetime, he achieved it, and it was satisfied. Another is liberation of Indians from oppression, suppression, and discrimination. I think I am right. I am exactly repeating what he earlier said. So this is the basis for our constitutional provisions according to me. The constitutional ambition is also same. What the Mahatma Gandhi ji has dreamt. That is, whatever may be the provisions you include in any of the statutes or the constitution or any law for the time being enforced, it should be towards the benefit of the public at large, to give him a dignified life. So what is dignified life then? Dignified life is referable to these affairs of a person. That means protection of the body. Once you take birth, even before taking birth, when a child is in the embryo sac of the mother, from that point of time the protection starts. You cannot diagnose whether it is a male child or a female. It is become an offense. He will be prosecuted if it is diagnosed. Because the protection should be given to the child right from that particular point of time when it enters the embryo sac of the mother, till the death and even after death. After that, what we will do? We will either bury the body or burn the body. So once the body is buried, you cannot exhumate without the proper permission of the competent authority. Till it mixes with the soil, till that point of time, you cannot engrave without the competent person's authority. So throughout, from the child enters into the embryo sac, even after the death, the body is protected. Not only in this way it is protected, we have so many laws emanate from the gates of the constitution, gates of the parliament and state legislature, that gives us so many laws which is concentrated towards the protection of the body of a person. Penal law with reference to the affecting the human body. There are so many laws. Whatever may be the law you take which is concentrating towards protection of the body. So the first and primary thing is protection of a person who lives in that particular nation. Protect him first. First you protect his body, keep him good health, both mental and physical. So that is the primary important laws they will legislate. That is one of the ambition of the constitution, to provide protection to the body, including good health. Even if you go to a doctor, doctor without your permission, he cannot touch your body. That's the law actually. But we ourselves will give our hand to the doctor. Doctor, please look me. I am suffering from fever from yesterday. Then doctor will touch your hand and give advice. It is what we in legal language call it as deemed consent. So that is the situation. Even without your permission, nobody in the earth can touch your body, let alone inflict your body. So infliction, even touching the body with malefied intentions are all made punishable, because to create deterrence in the mind of the people, to create fear in the mind of the people, to protect the rights created under law, so far as the people are concerned. This is so far as body is concerned. The second aspect is property. Protect the property of a person. What are all the nature of properties we have nowadays? Various type of properties, even the innovation you made, it is in your mind. Just like we say, earlier it was not there, copyright, trademark, your innovative activities, everything, even though it is in your mind, it is your property. So what are all visible, even invisible properties we recognized, corporeal and incorporeal properties. So those type of properties are also to be protected. We have made so many laws, including constitutional law. Keshavananda Bharati's case, right from the beginning, it is started to protect the properties also. So once the property is acquired, law says that you can acquire any huge property legally. You should acquire legally. So once you acquire the property, you are entitled to enjoy your property without any interference by anybody, without any hindrance. And you are also entitled to disposition of the property during your lifetime or even after your death, by means of giving a testamentary document like will. So this is the protection that has been given by the laws for acquisition of the property, for enjoyment of the property, and for disposition of your property. This is the second aspect. The third aspect is you have to live in the country with a dignified life, that once you have acquired a status, every person has got a status in the society. Whether he is an ordinary farmer or a peon in a government department or a professor or a lawyer, a judge, whoever he may be, the law presumes that he has got a status. That is the presumption of initial presumption of law. Unless it is rebutted by law itself, every person has got a status in the society. The protection of that status, the third limb of laws, which we have legislated to protect the status in the society. Status is gone to the extent of protecting the status of a child in the womb of a mother, or even so far as a dead person is concerned. We consider even an unborn child which is in the mother's womb has got a status. You cannot call that child as a vagabond or a bastard. If you call it, it will not only affect the child in the womb, but on the other hand, it affects the status of the mother or even father or the relatives of the child. Therefore, on that basis, if the status of a child is defamed, then the living persons who are affected can take appropriate legal action in accordance with law. Like that way, if the dead person is blamed, which is having effect of that blaming or defaming on the living persons also can take appropriate actions in accordance with law. So therefore, the status has to be protected. The dignity of a person has to be protected. So this is the ambition of the Constitution. Constitution, right from Golaknath's case till today, there's so many judgments of the apex court which define life. Life means what? It is not a life to live like a jackal or a dog. They explain it as a dignified life. It is the responsibility of every government, whether it is the state government or the central government, to provide those laws, to provide those facilities, to initiate such type of developmental activities in order to give a dignified life to a person. Whoever he may be, even a foreigner comes to us and lives for a limited period, how he should be treated in our country. Even unlawful enterers from other nations who are living in our country. In Bangalore, how many lots of people from other country, they are living even without a passport, let alone the visa. Even they have no passports at all. Such persons are living. But considering the human rights, we are not disturbing them from living here till they are identified and departed. Till that point of time, we must take care of such fellows also. We are not just identifying and throwing them out. We are giving them an opportunity now, whether they can prove they are the citizens of our country. In any manner they have acquired the citizenship. In any manner they are entitled to live in our country. If they establish that, they are at liberty to continue. If they don't establish, take law into force, depart them to their nation. So this is how our country is maintaining the equality amongst all, to give as far as possible dignified life to everyone. So for this dignified, to give a dignified life and liberty is extensively enlarged by the apex court. Liberty, the Supreme Court gone to the extent of saying that even preventive measures when you take, preventive detention. Preventive detention is a law which says that even without registering any case against anybody, without following any legal procedure for to initiate any criminal law against him, you can arrest a person for a limited period as a preventive measures. For that a separate law is there. General law is not applicable to them at all, because no bail, no trial, nothing is there except detaining him. That's why Preventive Detention Act is there, that procedure is established there or procedure is legislated. The Supreme Court says that very strict adherence to that law is to be made, to be adhered by the competent authority before arresting a person or before detaining a person under the Prevention of Detention Act. So right of liberty is very zealously safeguarded by the Constitution. Even without any reasons, nobody can be arrested. If he is arrested, there are so many provisions of law to safeguard his liberty. Bail provisions are there, parole provisions are there. So many provisions are introduced. Unless procedure established by law, you cannot curtail the liberty of any person. Like that way life. You cannot take away the life of anybody, or you cannot inflict anybody with any injury. So this is the main ambition of our constitution, and as well as all the statutory laws which emanate from the constitution. So how it is related to public administration? As I have already told you, these are all the three important segments the people use for their livelihood, for their life, to live in a particular nation. So for that, legislators have legislated so many laws for protection of body, protection of property, protection of status in the society. Apart from this, whether is it sufficient to give a dignified life is the question. Merely legislating laws for the protection of the body, protection of property, protection of status, is it sufficient for the purpose for to give a dignified life to a person who delves a nation? It is not sufficient. For that purpose, for to develop a person, personality, for to develop the nation, there are so many developmental activities introduced by the central government or the state government. To maintain the equal status, to maintain equality, so far to give a basic facilities to give equal status to live in the society. At least for the dignified life, what is required? He should have good health, number one. He should protect his body. He should have something to do work, something to earn, something to eat, something to have a status in the society. So this something is to be filled up now. How it is filled up? You see, for the purpose of taking care of health. How much development has already been taken place on the medical field? Lot of hospitals have been established. Mental health is taken care of. Physical health is taken care of. So for that, development activities will be an important segment of the governments. Even taking from a person lives in the remote area of a village. There we start a PHC. There we start some educational institutions for to give education to the children. The Constitution also explained free education to the children up to 14 years. No child labor. So these are all the new laws and developmental activities brought in by the governments. Roads are there, aeroplanes are there, trains are there, transport is improved, health purpose is improved, acquisition of properties, enjoyment of the properties in what manner. So for that, the government introduces various developmental activities, introduces various schemes for the benefit of the public at large. So if we say that something has been done by the governments, not only introducing laws but also various other productive activities or beneficial activities by introducing various schemes. For example, widow pension, old age pension, rights of senior citizens, free voyage, free in the trains, free in the bus for ladies, recently introduced. So these are all these various schemes that have been introduced by the various governments. including central government. So why these schemes have been introduced? For to see that a person lives a dignified, good life, happy life in that particular nation. So whatever the rights created to acquisition of these benefits given by the governments. For example, a widow pension is there. Let us take an illustration. A widow is there who lost her husband, who was only a breadwinner of the family. He makes an application before the competent authority, for example, Tahsildar. So this is the beneficial scheme introduced by the government for to protect the life of a widow and, if possible, to the kids of that widow. So for that purpose also they will introduce various circulars, various bylaws, various rules, various regulations to ascertain the eligibility criteria. So the schemes have been introduced again for the upliftment of the persons who are discarded or discriminated, to see that equality is maintained and even basic needs have been provided to them, at least to give them good life. Thus this is the main object of the public administration. So then what will become the affair? So widow has got a right to claim pension emanating from the law or by means of any introduction of any scheme. So like this way it is only a illustration. For protect your health you have got so many rights. To protect your property you have so many rights. To protect your status you have so many rights are created under so many laws, rules, regulations are like that. So once these schemes have been introduced, laws have been introduced, it is the responsibility of the parent proprietary, that is the governments, to see that reaches the common man. Merely because sitting in the ivory tower like Vidhan Sauda or in the parliament making laws are not sufficient. You must also see that the benefit out of those schemes and laws reaches a common man who lives in the remote corner of the village. That is the second ambition. How it can be reached? Who will be responsible to see that it reaches the common man? That is the responsibility of the public servants. You may call them as government servants or public servants. Whoever he may be, either a public servant or a government servant, we call them under the second category or second pillar of the constitution, that is executives. So the large responsibility is on the shoulders of the public servants to see that these benefits reaches a common man and it is accomplished, the intention of the governments are accomplished and he acquires that and enjoys the life. So in this manner the legislators or the laws will not only protect the rights of the persons, protect the life of the person, and also simultaneously regulate it. Regulation by means of imposing responsibilities on each and every person. As you know, rights and liabilities or rights and duties rather are two faces of the same coin. Everybody has got that right and responsibility to respect the right of another. So by this way, that they not only give right, they also give responsibilities to regulate what? To regulate the conduct. They regulate the conduct of the public. So affairs of the public not only include rights, but also include their responsibilities or duties regulated by law, rules and various regulations. So to administer the affairs of the public, these are all the important aspects they have created, the people have created, the governments have been created. The government means ultimately we are the government. They are all our representatives. That means we are ruling ourselves. Nobody is ruling us. It is a misnomer that the government is ruling us. It is a misnomer that the legislators are ruling us. No. We are ruling ourselves. So that is why whatever the requirement to the human being, that we are getting all those things, even to protect the environment, to protect water, protect air. Everything is regulated by us. So this is what we say, that public affairs are administered by means of introducing all these things. Then comes maladministration. What is meant by maladministration? Maladministration means by means of three aspects maladministration takes place. You have already studied law of torts. There it is said malfeasance, misfeasance and nonfeasance. What is meant by malfeasance or maladministration means doing an illegal act which is prohibited by any law for the time being enforced, while discharging your duty as a public servant, which is referable to a public administration. You are administering the affairs of the public, both legislators and as well as the executives and the judiciary to some extent. You are administering the affairs. Therefore, you are bound to follow law, legal aspects, and as well as see that the governmental schemes and public benefits reaches the common man as intended. If there is any maladministration, the affairs of the public is impaired by means of your misconduct. Largely it takes place in legislative activities and as well as executive activities. In one way, though, the legislators playing dual role. They are not only legislators but also public servants, and also to some extent they control the executives. Every minister is an executive officer, head of that particular institution. He has also got certain responsibilities. Therefore, the MLAs, MPs, MLCs, ministers, they not only act as legislators but also act as executives. So it is their responsibility to see that the affairs of the public is properly managed or maintained. So malfunctioning or maladministration or malfeasance, which says that you are discharging your duties, while discharging your duty as a public servant, as an executive, as a person who is responsible to see that the intention of the legislator reaches the common man. If you do an illegal act which is prohibited by law, what are all the acts that are prohibited by law? For example, Prevention of Corruption Act. Corruption is prohibited. Enforcing nepotism is prohibited. Doing an act with the influence of higher ups is prohibited. Casteism is prohibited. Practicing casteism while discharging your duty is prohibited. So these are all the several legal instances I can give you, that which are all prohibited by law. If you do that particular act which is prohibited by law, to see that these benefits doesn't reach a common man, then it amounts to maladministration or malfeasance. The second is misfeasance. Misfeasance means doing a legal act in an improper or irregular manner. Improper and irregular manner means you are doing the act in the legal parlance in accordance with law, but not timely giving the benefit. Not following certain procedures which are prescribed under law, but ultimately you have done that particular act after a long time. Delay in doing the act. Not following the regular procedures, improper manner, in an irregular manner. There also you are interfering with the administration. The third one is non-feasance or non-administration. That says that not doing an act which is mandated by law. You are bound to do that particular act in accordance with law, procedure, etc. in time, but you are not doing that act at all. You are so adamant. You are not only ignoring the law, but also you are seeing that that common man doesn't get that benefit at all for various reasons. So in this manner, if any public servant acts, it amounts to maladministration. So what is the consequence of this maladministration? Consequence is almost very, very severe. ಇಲ್ಲಿ ಬಂದ ಕನ್ನಡದಲ್ಲಿ ಒಂದು ಹೇಳ್ತೀನಿ, ಸಾಹೇಬರು ಈಗ ಹೇಳ್ತಾ ಇದ್ರು, ಪುರಂದರದಾಸರು ಈಗ ಸುಮಾರು 600 ವರ್ಷಗಳ ಹಿಂದೆ ಹೇಳಿದಂಥ ವಿಚಾರ. ಅವಾಗಲೇ ಮಾಲ್ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ಇತ್ತು. ಜನಗಳಿಗೆ ಸಲ್ಲಬೇಕಾಗಿದ್ದನ್ನ ಸರಿಯಾದ ರೀತಿ ಸಲ್ಲಿಸ್ತಿರ್ಲಿಲ್ಲ, ಬಿಕಾಸ್ ಆಫ್ ದಿಸ್ ಕರಪ್ಷನ್ ಅಂಡ್ ಅದರ್ ಥಿಂಗ್ಸ್. ಇನ್ಫ್ಲೂಯೆನ್ಸ್ ಇರ್ಬೋದು, ಕರಪ್ಷನ್ ಇರ್ಬೋದು, ಕ್ಯಾಸ್ಟಿಸಮ್ ಇರ್ಬೋದು, ಏನಾದ್ರು ಆಗಲಿ. ಅದಕ್ಕೆ ಅವ್ರು ಇನ್ನೊಂದು ಹೇಳಿದ್ರು, ತೃಣಮಪಿ ನ ಚಲತಿ ತೇನ ವಿನ. ತೃಣಮಪಿ ನಿನ್ನ ಒಂದು ಅವರು ದೇವರು ಹೋಲಿಸ್ತಾರೆ. ದೇವರ ಒಂದು ನಿಯಾಮಕ ಇಲ್ಲದಿದ್ದರೆ ಒಂದು ಹುಲ್ಕಡ್ಡಿನೂ ಅಲ್ಲಾಡೋದಕ್ಕೆ ಸಾಧ್ಯತೆ ಇಲ್ಲ, ಎಲ್ಲ ದೈವಚಿತ್ತ ಅಂತ ಅವರ ಒಂದು ಹೇಳೋದು. ಆದ್ರೆ ಇವಾಗ ಏನಾಗಿದೆ ಈ ಪರಿಸ್ಥಿತಿ ಅಂತಂದ್ರೆ, ತೃಣಮತಿ ನಚಲತಿ ಹಣದ ವಿನ ಅಂತ. ಯಾವ ಕೆಲಸನೂ ಯಾವುದೇ ಆಫೀಸ್ಗೆ ಹೋಗಿ, ಯಾವುದೇ ಗೌರ್ಮೆಂಟ್ ಆಫೀಸ್ಗಳಿಗೆ ಹೋಗಿ ಒಂದು ಫೈಲು 1 ಇಂಚು ಕೂಡ ಮೂವ್ ಆಗೋದಿಲ್ಲ ವಿತೌಟ್ ಏನಿರ್ಬೇಕು ಇದಕ್ಕೆ. ಈಗಿನ ಕ್ಯಾರೆಕ್ಟರಿಸ್ಟಿಕ್ಸ್, ವಾಟ್ ಈಸ್ ರಿಕ್ವೈರ್ಡ್ ಟು ಮೂವ್ ಎ ಫೈಲ್ ಅಂತಂದ್ರೆ, ಐದರ್ ಯು ಶುಡ್ ಕರಪ್ಟ್ ಹಿಮ್ ಬೈ ಮೀನ್ಸ್ ಆಫ್ ಪೇಯಿಂಗ್ ಮನಿ, ಆರ್ ಇನ್ಫ್ಲೂಯೆನ್ಸ್ ಹಿಮ್ ಬೈ ಹೈಯರ್ ಅಪ್ಸ್, ಆರ್ ಕ್ಯಾಸ್ಟಿಸಮ್, ಆರ್ ನೆಪೋಟಿಸಮ್. ಇವನು ನಮ್ಮವನು, ನಮ್ಮ ಜಾತಿ, ನನಗೆ ಬೇಕಾದವನು, ನನ್ನ ಬಾಮೈದ, ಅವನ ಕೆಲಸ ಮಾಡೋಣ. ಇವನು ನಮ್ಮ ಜಾತಿ, ಅವನ ಕೆಲಸ ಮಾಡೋಣ. ಇವನು ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದಾನೆ, ಲಂಚ, ಅವನ ಕೆಲಸ ಮಾಡೋಣ. ಸೊ ಪ್ರಾಮಿನೆನ್ಸ್ ಯಾವುದಕ್ಕೆ ಸಿಗ್ತಾ ಇದೆ ಇವಾಗ ಅಂತಂದ್ರೆ, ಸೊ ಪ್ರಾಮಿನೆನ್ಸ್ ಈಸ್ ಗಿವನ್ ಟು ದಿಸ್ ಕರಪ್ಷನ್, ನೆಪೋಟಿಸಮ್, ಇನ್ಫ್ಲೂಯೆನ್ಸ್, ವಿಚ್ ಆರ್ ಪ್ರಾಹಿಬಿಟೆಡ್ ಬೈ ಲಾ, ವಿಚ್ ಆರ್ ಪ್ರಾಹಿಬಿಟೆಡ್ ಬೈ ಲಾ. ಸೊ ಹಾಗಾದಂಥ ಸಂದರ್ಭದಲ್ಲಿ ವಾಟ್ ಈಸ್ ದಿ ಸೊ ಎಕ್ಸಿಕ್ಯೂಟಿವ್, I was on the point that what is the consequence of this maladministration? ಅವ್ರು maladministration ಮಾಡೋದ್ರಿಂದ ಏನೇನು ಆಗ್ತಾ ಇದೆ ಇವತ್ತಿನ ದಿವಸ. See, I have seen 3 categories of persons who approaches our institution. Any vigilance institution, any type of vigilance institution, whatever the name you call them. Number 1 is the persons who are unable to meet the requirement of a public servant, this is illegal requirements. They are unable to meet that. They are so downtrodden, and their helplessness made them to approach our institution for help. The second category of people who live on principle basis, who are living a principled life, value-based life, who are of the opinion in their life, let whatever may come, I will not take even a single pie to do my work, or I will not give a single pie to anybody for my work. I will get it done in accordance with law. Let whatever may come, I will fight. I will fight forever throughout my life, but I will not budge even an inch. So this type of people who are principled, who are value-based, living a value-based life, those persons will not corrupt the society, and they will approach the competent authorities and try throughout their life to get their right or get the public rights solved. They will not only fight for their benefit, they will fight for the society. Such type of people, second category, they come. The third category, who are worst compared in all the other categories, they are the persons who want to inflict the honest fellows. The public servants who are honestly working, discharging their duties, to inflict them for the purpose of getting their illegal work done. Such persons also approach our institution. So I am not much talking about the judiciary, because once the right is violated, then only judiciary will come into picture. So far as public administration is concerned, these two segments are very important. Therefore, I am concentrating on these two segments of the Constitution. So the consequence would be very severe. I will give you one example, that in continuation of that widow pension, or let us take a Motor Vehicles Act. Under Motor Vehicles Act, if a lady lost her husband in an accident, who was only the breadwinner, no other source of income, no other source for livelihood, she makes an application for grant of interim compensation. For immediate livelihood, there should be something to live. So if at appropriate time, if the interim compensation is not granted, or if a wife deserted by the husband having 2 children, interim maintenance is not granted at the right point of time. A widow who made an application at the right point of time, if the pension is not granted, what would be the consequence? What is the impact of this? For the purpose of her livelihood, in so many instances we have seen, she has become prostitute. The children have become thieves, robbers. In either of the occasions, you see the impact of this delay in granting or not granting, even though she complies all the criteria. The consequence would be very severe. This type of maladministration destroys the moral fiber of each and every person in the society who want to live a dignified life, who want to adhere to law, who want to live a principled, value-based life. That fiber will be destroyed if we allow these things to happen in future. A contractor, nowadays it is talk of the town. Without giving 40% or 50%, 60%, whatever may be the percentage, they cannot do the work at all. No work entrustment. Whose money is this? It is the money for the benefit of the public at large, for to manage the affairs of the public. That is being wasted. That is being concentrated for corruption. Who is responsible for all these things? Are we also not responsible for this? We must put question to ourselves. Then only we will understand what is our role. Then only we will understand particularly what is the role of a law-abiding citizen, a law graduate or a law student or a lawyer. Why we are distinguishing from other common man to a lawyer? We are distinguishing because of the reason that compared to other common man, we are in legal studies, we understand what is going on in the society, whether it is legally going on or there is any adherence by these three segments of the constitution to law and rules, regulations. Whether at right point of time we are questioning it. At right point of time we are trying to protect it. So therefore, the lawyers and public, and as well as law students. Why I am always concentrating on law students? Because you are the future citizens of our country. You are the persons considered as a elevated class, enlightened class, who can help the public, who can help the society at large. If you look at right from prior to independence, or even after independence, almost the political leaders, judicial system, are all lawyers who have occupied a prominent positions in the society. Basically, they were all lawyers. Ministers, central ministers, advisors to the governments, they are all lawyers. That is why you may become a corporate, you may become a lawyer, later you may become an advisor, whatever you want to become. But you must understand that what is our public administration, how it should take place, how it should be, whether it is going away from the track, how to bring it back to the track. Is it not our responsibility to see that a corruption is taking place, we have to pull it out, bring it to the notice of the competent authority. Without, you must not think over what would be the consequence. If it is brought to the knowledge of a competent authority, let us say a corruption is taking place in an office, you bring it to the notice of the competent authority, that is a police or Upalokayukta police, whatever it may be, or the vigilance wing. You may think that even if I lodge a complaint, they may not take any appropriate action. That is also there. The person who has to take appropriate measures at right point of time, if he doesn't take that action because of this maladministration again, he might have been corrupted. Highest officer also might have been corrupted. Therefore, throughout, no action. So thinking in that line, whether we can keep quiet is the question. ನಾನು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟರೂ ಕೂಡ ಏನು ಪ್ರಯೋಜನ ಆಗಲ್ಲ. ಯಾಕೆಂದ್ರೆ ನಂತರ ಬೇಕಾದಷ್ಟು ಈಗಾಗಲೇ ಕಂಪ್ಲೇಂಟ್ಗಳು ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಕೊಟ್ಟಿದ್ರು ಕೂಡ ಅದೇನು ಸಾಲ್ವೇಷನ್ ಆಗಲಿಲ್ಲ. ಯಾವುದೇ ಆಕ್ಷನ್ ಆ ಡಿಪಾರ್ಟ್ಮೆಂಟು ಕೂಡ ತಗೊಳ್ಳಿಲ್ಲ, ಹೈಯೆಸ್ಟ್ ಆಫೀಸರು ತಗೊಳ್ಳಿಲ್ಲ ಅಂತ ಯೋಚನೆ ಮಾಡಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಡೋದನ್ನೇ ನಿಲ್ಲಿಸಿದ್ರೆ ಏನಾಗಬಹುದು? So this maladministration will become rampant. Totally lawlessness will be created. Then jungle law will prevail. All our laws will vanish. So therefore, you are all the citizens of the country. It is your responsibility, your role, not only to protect the rights of the persons, you are also responsible to protect the right of the society at large. You have what I have studied in law, there are personal rights and private rights and public rights. Personal and private rights are attributable to a particular person. The public rights are not only applicable to that particular person, it is also applicable to the public at large. Anybody can initiate the proceedings. You might have studied public interest litigations. Public interest, wherever it is involved, even though you may not ask for any benefit arising out of your personal right, but it is your duty to see that the public beneficial activities, if it is suffering from any maladministration, every citizen, every person in that particular country or area is entitled to raise his finger, entitled to raise the question. Suppose if one person rises, why I am concentrating this to our legal community is that if a lawyer raises a question, if an ordinary man raises a question, is of two different nature. Lawyer will pursue it on the legal background, and he know if his application is not properly considered, what to do. Therefore, if the lawyers make up their mind, law students make up their mind, if public make up their mind to interfere wherever there is maladministration by the executives, to some extent you cannot completely destroy it or eradicate it, but to some extent we can start preventing it. ಈಗ ಅದಕ್ಕೆ ಕರಪ್ಷನ್ ಆಕ್ಟ್, ಎರಾಡಿಕೇಶನ್ ಆಫ್ ಕರಪ್ಷನ್ ಆಕ್ಟ್ ಅಂತ ಮಾಡಲೇ ಇಲ್ಲ. The act is not called as eradication of corruption act. It is prevention of corruption act. Means the lawmakers also know that it cannot be eradicated. In fact, they want that. You see, I must say with pain that Prevention of Corruption Act is drastically amended now. Drastically amended, bringing certain provisions in protection of the persons who are corrupt. Not to protect the public at large, not to punish severely so far as the corrupt people are concerned, but to protect them. One of the provision under section 17A of prevention, recently you might have read in the newspapers, Governor has given sanction to investigate the matter against Chief Minister. Muda case, it is famously known as Muda case. The investigation is going on. God only knows what will happen. And another petition is also pending. That is why I told you that if you give an application before the competent authority also doesn't take action, you should not stop at that level only. You must pursue it. One fine day we may succeed. You may not succeed, but the person who pursues that, even after you, he may succeed. Therefore, with great ambition, we have to start with this public activity. So that 17A, what they have introduced is that even for the purpose of investigation, in certain cases, sanction is necessary. Except the provisions under section 7 and 13 of the Prevention of Corruption Act, for investigation under other provisions of the Prevention of Corruption Act, even for investigation, the sanction of the government or the competent authority is necessary. It is the double protection. One is sanction for investigation or permission for investigation, and next is after investigation to prosecute him under section 19, one more sanction. See how they want to screen the offences, how they want to protect the corrupt people. So how we must be very careful in dealing with such persons who are more in number. Percentage is almost 80:20. 80% corruption. 20% we may get honest or sincerely discharging executives. So we must reverse it. ಸಾಹೇಬ್ರು ಹೇಳಿದ್ರು ಅವಾಗ ಅಷ್ಟಿತ್ತು ಅಂತ. ಇಲ್ಲ ಇಷ್ಟಿತ್ತು. ಪುರಂದರದಾಸ್ ಇದ್ದಾಗ 600 ವರ್ಷಗಳಿಂದ 20:80 ಇತ್ತು. ಇವಾಗ 80:20 ಆಗಿದೆ. ಅದನ್ನು ರೆಸ್ಟೋರ್ ಮಾಡಬೇಕಾದಂಥ ಸಮಯದಲ್ಲಿ ಮಾಡಬೇಕಾದ್ರೆ the law students, we must understand what is our role. As good citizens of the country in future, how we should take the affairs of the public to protect their affairs, manage the affairs. Once we become executives, how we should behave. You may become law officers, you may become government officials, you may become politicians. Whatever you want to become, you become. But you must take oath now itself. Now itself, at least your generation. If your generation start taking oaths now itself, whatever I become in future, I not only live a dignified life, but I will be honest to myself and to the society. That is the exact role you have to play, number one. Then what you will do, you will not affect the rights of any person. On the other hand, you will agitate your right and get whatever the benefit out of your right. So not then you are safe and society is also safe so far as you are concerned, because you are not causing any infliction to anybody, any damage to anybody's right, but you are not helping others. ಅದಕ್ಕೆ ಒಂದು ಕನ್ನಡದಲ್ಲಿ ಒಂದು ಸಣ್ಣ ಕಥೆ ಇದೆ, ಹೇಳಿ. ಐ ವಿಲ್ ಕನ್ಕ್ಲೂಡ್ ವಿತ್ ಇನ್ ಅನದರ್ 5 or 10 minutes. ಅಕ್ಬರ್ನ ಆಸ್ಥಾನಕ್ಕೆ ಒಬ್ಬ ದೊಡ್ಡ ವಿದ್ವಾಂಸ ಹೋದಂತೆ. ಅವನು 3 ಬೊಂಬೆ ತಗೊಂಡು ಹೋಗಿದ್ನ. ಆ 3 ಬೊಂಬೆನ ಆಸ್ಥಾನದಲ್ಲಿಟ್ಟು ಈ 3 ಬೊಂಬೆ ಏನು ಹೇಳುತ್ತೆ ಅದಕ್ಕೆ ವಾಟ್ ಮೆಸೇಜ್ ದೀಸ್ ಡಾಲ್ಸ್ ಗಿವ್ ಟು ದಿ ಸೊಸೈಟಿ. ಎಲ್ಲರೂ ನೋಡಿದ್ರಂತೆ, ತಿರುಗಿಸಿ ಮರುಗಿಸಿ ನೋಡಿದ್ರು, ಏನೇನು ಮಾಡಿದ್ರು ಯಾರಿಗೂ ಗೊತ್ತಾಗಿಲ್ಲ. ಯಾಕೆಂತಂದರೆ ಅಬ್ಸಲ್ಯೂಟ್ಲಿ ನೋ ಚೇಂಜ್ ಫ್ರಮ್ ಒನ್ ಡಾಲ್ ಟು ಅನದರ್. ಅದು ಮಹಾತ್ಮ ಗಾಂಧಿ ಥರ ಬೊಂಬೆ ಅಲ್ಲ. ಅದು ನೋಡಿದ ತಕ್ಷಣ ಹೇಳ್ಬೋದು, ಕೆಟ್ಟದ್ದನ್ನು ಕೇಳಲ್ಲ, ಕೆಟ್ಟದ್ದನ್ನು ನೋಡಲ್ಲ, ಕೆಟ್ಟದ್ದನ್ನು ನುಡಿಯಲ್ಲ. 3 ಬಾಯಿ ಮುಚ್ಕೊಂಡಿದೆ, ಒಂದು ಕಣ್ಣು ಮುಚ್ಕೊಂಡಿದೆ, ಒಂದು ಕಿವಿ ಮುಚ್ಕೊಂಡಿದೆ. ಎನಿಬಡಿ ಕ್ಯಾನ್ ಇಮ್ಯಾಜಿನ್ ಅಂಟ ವಾಟ್ ಮೆಸೇಜ್. ಸೊ ಇಲ್ಲಿ ಹಾಗಲ್ಲ, ಏನು ಗೊತ್ತಾಗ್ತಿಲ್ಲ ಅದರಲ್ಲಿ, ಏನು ಎಲ್ಲ ಒಂದೇ ಥರ ಇದೆ. ಯಾರು ನೋಡಿದ್ರು ಬೊಂಬೆ ನೋಡಿದ ತಕ್ಷಣ ಏನೂ ಗೊತ್ತಾಗಲ್ಲ. ಸೊ ಎಲ್ಲರೂ ನೋಡಿದ್ರು ಯಾರಿಗೂ ಗೊತ್ತಾಗಲಿಲ್ಲ. ಅಕ್ಬರ್ ಅಂದ, ಇವತ್ತು ನಮ್ಮ ಮರ್ಯಾದೆ ಹೋಯ್ತು, ಯಾರಿಗೂ ಇಲ್ವೋ ಇಷ್ಟು ದೊಡ್ಡ ದೊಡ್ಡ ವಿದ್ವಾಂಸ ಕಂಡುಹಿಡಿಯೋಕ್ಕೆ. ಅಷ್ಟೊತ್ತಿಗೆ ಬೀರ್ಬಲ್ ಅಲ್ಲಿದ್ದ. ಅವನು ಒನ್ ಆಫ್ ದಿ ಮೋಸ್ಟ್ ಇಂಟೆಲಿಜೆಂಟ್ ಮಿನಿಸ್ಟರ್ಸ್ ಇನ್ ದಿ ಅಕ್ಬರ್ಸ್ ಕೋರ್ಟ್. ಅಕ್ಬರ್ ಅವ್ನು ಹೇಳ್ದ, ನೋಡಪ್ಪ ನೀನಾರು ಮರ್ಯಾದೆ ಉಳಿಸು. ಅವನು ನೋಡಿ ತಿರುಗಿಸಿ ಮುರುಗಿಸಿ ಎಲ್ಲ ನೋಡ್ದ, 1 ಗಂಟೆ ನೋಡ್ದ, ಏನೂ ಗೊತ್ತಾಗಲಿಲ್ಲ ಅವನು. ಆದರೆ ಬೇರೆಯವ್ರಿಗೆಲ್ಲ ಎಲ್ಲರಿಗಿನ್ನ ಬುದ್ಧಿವಂತ ಅಲ್ಲ, ಅಲ್ಲೊಂದು ಚೂರು ಒಂದು ಬುದ್ಧಿವಂತಿಕೆ ತೋರಿಸ್ತಾ. ಏನಪ್ಪ ಅಂದರೆ, ನನಗೆ ಒಂದು ದಿನ ಈ ಬೊಂಬೆ ನಾನು ಮನೆಗೆ ತೊಗೊಂಡೋಗಕ್ಕೆ ಕೊಡಿ, ನಾಳೆ ಬಂದು ನಾನು ಹೇಳ್ತೀನಿ ಸಾಧ್ಯವಾದರೆ ಅಂತ. ಒಂದು ವಾರ ಇಟ್ಕೊಡ್ರಿ ಬೇಕಾದ್ರೆ, ಒಂದು ದಿನ ಅಲ್ಲದಿದ್ರೆ ಏನು ಅಂತ. ಅವನು ವಾಸ್ ಸೋ ಕಾನ್ಫಿಡೆಂಟ್, ಯಾರು ಏನು ಹೇಳೋಕ್ಕಾಗಲ್ಲ ಅಂತ. ಸರಿ, ಮನೆಗೆ ತೊಗೊಂಡೋಗ. ಮನೆಗೆ ತೊಗೊಂಡೋಗ ರಾತ್ರಿ ಎಲ್ಲ ಯೋಚನೆ ಮಾಡಿದ್ರೆ, ಇದ್ದೇ ಮಾಡಲಿಲ್ಲ ರಾತ್ರಿ ಎಲ್ಲ. ಇವತ್ತು ಎದುರು ಇಟ್ಕೊಂಡು ಕೂತ್ಕೊಂಡಿದ್ದಾನೆ, ತಿರುಗಿಸ್ತಾರೆ ಮರುಗಿಸ್ತಾರೆ, ಏನೂ ಮಾಡೋಕ್ಕೆ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ. ಸರಿ, ಬೆಳಗ್ಗೆ ಎದ್ದು ಇನ್ನೇನು ಆಸ್ಥಾನಕ್ಕೆ ಹೋಗಬೇಕು ಅಂತ, ಇವತ್ತು ಮರ್ಯಾದೆ ಹೋಗುತ್ತೆ, ನಂದು ಹೋಗುತ್ತೆ, ಅಕ್ಬರ್ದು ಹೋಗುತ್ತೆ ಅಂತ ಹೊರಡೋಕ್ಕೆ ಶುರು ಮಾಡ್ದ. ಅವನ ಮಗಳು ಝರೀನಾ ಅಂತ ಒಬ್ಬಳು ಅದ್ರ ಬೊಂಬೆ ಜೊತೆ ಆಟ ಆಡ್ತಾ ಇತ್ತು. ಅವಳು ಒಂದು ಕಿವಿನಲ್ಲಿ ಆ ಬೊಂಬೆಗೆ ಒಂದು ದಾರ ತೋರಿಸಿದ್ಲು, ಅದು ಇನ್ನೊಂದು ಕಿವಿಯಿಂದ ಈಚೆ ಬಂತು. ಸೊ ಹಿ ಗಾಟ್ ದಿ ಮೆಸೇಜ್. ಇಮ್ಮಿಡಿಯೇಟ್ಲಿ ಹಿ ಕೇಮ್ ಬ್ಯಾಕ್ ಟು ದಿ ಕೋರ್ಟ್ ಆಫ್ ಅಕ್ಬರ್. ಹೇಳ್ದ ಬಂದು, ಇದು ನೋಡಿ, ಪ್ರಪಂಚದಲ್ಲಿ 3 ಥರ ಕ್ಯಾಟಗರಿ ಜನಗಳಿರ್ತಾರೆ. ನಂಬರ್ 1, ಈ ಕಿವಿಯಿಂದ ಕೇಳಿದ್ದನ್ನ ಈ ಕಿವಿ ಒಳಗೆ ಸೀದಾ ಬಿಡ್ತಾ ಇರ್ತಾರೆ, ಮೇಲೆ ತಗೊಳ್ಳೋದೇ ಇಲ್ಲ. ಅಂದರೆ ಅವರು ತಮ್ಮ ಜೀವನದಲ್ಲಿ ಏನೇ ಕೇಳಲಿ, ಏನೇ ಹೇಳಲಿ, ಏನೇ ನೋಡಲಿ, ಏನೇ ಮಾಡಲಿ, ತಮ್ಮ ಬುದ್ಧಿಯನ್ನು ಏನೂ ಉಪಯೋಗಿಸೋದ ಪ್ರಶ್ನೆನೇ ಇಲ್ಲ. ಕೇಳಿದ್ದನ್ನೆಲ್ಲ ನೋಡಿದ್ದನ್ನೆಲ್ಲ ಈ ಕಿವಿಯಿಂದ ಕೇಳಿ ಈ ಕಿವಿಯಿಂದ ಬಿಟ್ಬಿಡ್ತಾರೆ. ಇವ್ರು ಯಾರಿಗೂ ಪ್ರಯೋಜನ ಇಲ್ಲ. ಅಂದರೆ ತಮಗೇ ಪ್ರಯೋಜನ ಇಲ್ಲ ಮೊಟ್ಟ ಮೊದಲು, ಇನ್ನು ಬೇರೆಯವ್ರಿಗೆ ಪ್ರಯೋಜನ ಹೇಗಾಗುತ್ತೆ? ಫಸ್ಟ್ ಕ್ಯಾಟಗರಿ. ಸೆಕೆಂಡ್ ಕ್ಯಾಟಗರಿ, ದಾರ ತೂರಿಸ್ತಾ ಇನ್ನೊಂದು ಕಿವಿಯಿಂದ ಅದು ಈಚೆಗೆ ಬರಲಿಲ್ಲ. ಎಲ್ಲಿಗೋಯ್ತು? ಇವನು ಹೇಳ್ದ, ಇವರು ಪ್ರಪಂಚದಲ್ಲಿ ಸ್ವಾರ್ಥಿಗಳು. ಯಾರೇನೇ ಹೇಳಿದ್ರು ಕೇಳ್ತಾರೆ, ಏನೇ ನೋಡಿದ್ರು ತಿಳ್ಕೊತಾರೆ, ಜೀವನದ ಅನುಭವನೆಲ್ಲನೂ ಸೇರಿಸ್ತಾರೆ, ತಮ್ಮ ಚಿಂತನ ಮಂಥನ ಮಾಡಿ ತಮ್ಮ ತಲೆಯಲ್ಲಿರೋದು ಅದನ್ನು ಸೇರಿಸ್ಕೋತಾರೆ, ಆದರೆ ತಮ್ಮೊಳಗೆ ಇಟ್ಕೋತಾರೆ, ತಮಗೋಸ್ಕರ ಬಳಸ್ಕೋತಾರೆ. ಸಮಾಜಕ್ಕೋಸ್ಕರ ಆಗಲಿ ಬೇರೆಯವರಿಗೋಸ್ಕರವಾಗಲಿ ಇದನ್ನು ಬಳಸೋದಿಲ್ಲ. ಸ್ವಾರ್ಥಿಗಳು. ಈ ಎರಡೂ ಕ್ಯಾಟಗರಿ ಬೇರೆಯವ್ರಿಗೆ ತೊಂದರೆ ಕೊಡದಿದ್ರೂ ಕೂಡ ಸಮಾಜಕ್ಕೇನು ಅನುಕೂಲತೆ ಇಲ್ಲ ಇವರಿಂದ. ತಮ್ಮನ್ನು ತಾವು ನೋಡ್ಕೋತಾರೆ, ಬೇರೆಯವ್ರಿಗೆ ತೊಂದರೆ ಕೊಡದೇ ಇದ್ರು ಕೂಡ. 3ನೇ ಕ್ಯಾಟಗರಿ, ಇನ್ನು ಕಿವಿ ತೂರಿಸ್ದ, ಅದು ಬಾಯಿಂದ ಹೊರಗಡೆ ಬಂತು. ಹೇಳ, ಇವರು ಸಮಾಜಕ್ಕೆ ಬೇಕಾದಂಥ ವ್ಯಕ್ತಿಗಳು. ಎರಡೂ ಕಿವಿಲಿ ಕೇಳ್ತಾರೆ, ನೋಡಿದ್ದನ್ನು ಅನುಭವಿಸ್ತಾರೆ, ತಾವು ತಮ್ಮ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ನೆಲ್ಲ ಸೇರಿಸ್ತಾರೆ, ತಮ್ಮ ತಲೆಗೆ ತಗೊಂಡು ಚಿಂತನ ಮಂಥನ ಮಾಡ್ತಾರೆ. ಇದ್ರ ಜೊತೆ ನಮ್ಮ ಕಾಂಟ್ರಿಬ್ಯೂಷನ್ ಏನು ಮಾಡ್ಬೋದು, ಇದು ಸಮಾಜಕ್ಕೆ ಏನು ಬೆನಿಫಿಟ್ ಆಗುತ್ತೆ ಅಂತಂದು ಇಡೀ ಸಮಾಜಕ್ಕೆ ಅದಕ್ಕೆ ಪ್ರಸರಣ ಮಾಡ್ತಾರೆ. ದಿಸ್ ಇಸ್ ಥರ್ಡ್ ಕ್ಯಾಟಗರಿ. ಅಂದರೆ ಈ 3ನೇ ವ್ಯಕ್ತಿಗಳು ಬರೀ ತಾವು ತಿಳ್ಕೊಂಡಿದ್ದು ಹೇಳಲ್ಲ, ಸಮಾಜದಲ್ಲಿ ಆಗ್ತಿರ್ತಕ್ಕಂಥ ಲೋಪದೋಷಗಳನ್ನು ಕೂಡ ಕಂಡುಹಿಡಿತಾರೆ, ಉಬ್ಬು ತಗ್ಗುಗಳನ್ನು ಸರಿ ಮಾಡ್ತಾರೆ, ಡೊಂಕುಗಳನ್ನು ಸರಿ ಮಾಡ್ತಾರೆ, ಸಮಾಜಕ್ಕೆ ಒಂದು ಉತ್ತಮವಾದಂಥ ವಾತಾವರಣ ಕ್ರಿಯೇಟ್ ಮಾಡೋದಕ್ಕೆ ಪ್ರಯತ್ನ ಮಾಡ್ತಾರೆ ಇವರು 3ನೇ ಕ್ಯಾಟಗರಿ. ಅದಕ್ಕೆ ನಾನು ಹೇಳೋದು, ಲಾ ಸ್ಟೂಡೆಂಟ್ಸ್ ಶುಡ್ ಕ್ಯಾಟಗರೈಸ್ ದೆಮ್ಸೆಲ್ಸ್ ಆಸ್ ದಿ ಥರ್ಡ್ ಡಾಗ್. ಆ ಒಂದು ನಿಟ್ಟಿನಲ್ಲಿ ನಾವು ಇವತ್ತಿನ ದಿವಸ ನಮ್ಮ ಕಾನೂನುಗಳನ್ನು ಅಧ್ಯಯನ ಮಾಡಿದ್ವಿ. ಇಫ್ ಯು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ದಿ ಆಂಬಿಷನ್ ಆಫ್ ದಿ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ and all the other laws for the time being in force, rules, regulations and duties of the legislature, executive and the judiciary, it concentrates only towards to give good life to the citizen or good life to the person who is living in that particular nation. For that, what best we can contribute? You are the person who become lawyers, who can go up to the grassroots level to help the people at large, who don't know about their rights, their liabilities. Judiciary is only meant for administration of justice in accordance with law. But lawyers who can act as lawyers in the court hall, but as a social architect out of the court. You must act as a social architect, utilize your everything, what you have acquired from the society. ಇದೆಲ್ಲ ಕೊಟ್ಟಿದೆ ಸೊಸೈಟಿ, ನಮಗೇನು ಕೊಟ್ಟಿದೆ? ಸ್ವಾಮಿ ವಿವೇಕಾನಂದರು ಹೇಳಿದಾಗೆ, ಸದಾಕಾಲ ದೇಶ ನನಗೇನು ಕೊಡ್ತು ಅಂತ ಕೇಳೋದಕ್ಕಿಂತ ದೇಶ ನನಗೆ ಕೊಟ್ಟಿದೆ, ಆ ಕೊಟ್ಟಿರೋದಕ್ಕೆ ನಾನೇನು ಕೊಟ್ಟೆ ಅಂತ ಯಾವತ್ತಾರು ಪ್ರಶ್ನೆ ಮಾಡ್ಕೊಂಡಿದ್ದೆ. ಮುಂದಕ್ಕೆ ಹೇಳ್ತಾರೆ ಏನು ಕೊಡದೇ ಇದ್ರು ಬೇಡ ಬೇಡ, ಕನಿಷ್ಠ ಅಂದರೆ ನನ್ನಷ್ಟಿಗೆ ನಾನು ಪ್ರಾಮಾಣಿಕವಾದ ಜೀವನ ಮಾಡ್ತೀವಿ ಅಂತಕ್ಕಂಥ ಒಂದು ಅಶ್ಯೂರೆನ್ಸ್ನ ಸಮಾಜಕ್ಕೆ ಕೊಟ್ಟರೆ, ನೀವು ಬೇರೆಯವ್ರಿಗೆ ಸಹಾಯ ಮಾಡದೇ ಇದ್ರೂ ಕೂಡ ನೀವು ಕರೆಕ್ಟ್ ಆಗಲ್ಲ, ನೀವು ಪ್ರಾಮಾಣಿಕರಾಗಿರ್ತೀವಿ ಅಂತ ಒಂದು ಅಶ್ಯೂರೆನ್ಸನ್ನು ಸಮಾಜಕ್ಕೆ ಕೊಟ್ಟರೆ ಅದಕ್ಕಿಂತ ದೊಡ್ಡ ಕಾಂಟ್ರಿಬ್ಯೂಷನ್ ಬೇರೋದಿಲ್ಲ. So therefore, my dear friends, we must understand our role now. We are the future pillar of our country. Judiciary, not only administration of justice according to law inside the court, you must play your role effectively more than what you are playing inside the court. You must play your role outside the court. Therefore, thanks for giving an opportunity to share a few of my thoughts with you. And you must understand your role. And I hope that you will not only become good persons, very good persons, excellent persons, but a great persons to our country. What is the difference? Just what I said. ಮೂರ್ತನ ಬೊಂಬೆಗಳು. If you leave yourself, selfishness, but don't interfering with the others' rights, ಪ್ರಾಮಾಣಿಕವಾದ ಜೀವನ. ದಟ್ ಈಸ್ ವಾಟ್ ಸ್ವಾಮಿ ವಿವೇಕಾನಂದ ಸೆಡ್. ಅಂದ್ರೆ ಅವ್ರು ಹೇಳ್ತಿದ್ರು, ಏನೂ ಕೊಡಕ್ಕಾಗದೇ ಇದ್ದರೂ ಕೂಡ ಅವ್ರು ಹೇಳೋದು, ನೀವೇನೂ ಕೊಡೋದು ಬೇಡ ದೇಶಕ್ಕೆ, ಏನೂ ಕೊಡಕ್ಕಾಗದೆ ನನ್ನಷ್ಟಿಗೆ ನಾನು ಪ್ರಾಮಾಣಿಕವಾಗಿರ್ತೀನಿ ಅಂದರೆ ದಟ್ ಈಸ್ ದಿ ಗ್ರೇಟ್ ಕಾಂಟ್ರಿಬ್ಯೂಷನ್ ಅಂತಂದರು. ಆದರೆ ಗ್ರೇಟ್ ಪರ್ಸನಾಲಿಟೀಸ್ ಹೇಗಾಗ್ತಾರೆ ಅಂತಂದರೆ ಗುಡ್ ಪರ್ಸನ್ಸ್, ವೆರಿ ಗುಡ್ ಪರ್ಸನ್ಸ್. ಸೊ ನಮ್ಮ ಪಾರ್ಟಿಗೆ ನಾವು ಇರ್ತೀವಿ, ಬೇರೆ ಯಾರಿಗೂ ತೊಂದರೆ ಕೊಡೋಲ್ಲ, ನಮ್ಮ ರೈಟ್ ನಾವು ಎಜುಕೇಟ್ ಮಾಡ್ತೀವಿ, ನಮ್ಮಷ್ಟಿಗೆ ನಾವು ಇರ್ತೀವಿ, ಯಾರಿಗೂ ತೊಂದರೆ ಕೊಡೋಲ್ಲ. ಗುಡ್, ವೆರಿ ಗುಡ್. ಎಕ್ಸಲೆಂಟ್ ಮೀನ್ಸ್ ನಾನು ಚೆನ್ನಾಗಿರ್ತೀನಿ, ನನ್ನ ಕೈಲಾದಷ್ಟು ಬೇರೆಯವ್ರಿಗೆ ಸಹಾಯ ಮಾಡ್ತೀನಿ, ನನ್ನ ಕೈಲಾದಷ್ಟು, ನಾಟ್ ಎಕ್ಸೀಡಿಂಗ್ ಮೈ ಲಿಮಿಟ್. ನನ್ನ ಲಿಮಿಟೇಷನ್ಸ್ ಏನಿದೆ ಅಷ್ಟೊಳಗೆ ನಾನು ಮಾಡ್ತೀನಿ. ನನಗೆ ಒಂದು 1000 ರೂಪಾಯಿ ನನಗೆ ಆದಾಯ ಇದೆಯಾ, ಯಾವನಿಗೋ ಒಂದು 100 ರೂಪಾಯಿಯೋ 10 ರೂಪಾಯಿಗೋ ಕಷ್ಟ ಬಂತು, ನನ್ನ ಲಿಮಿಟೇಷನ್ಸ್ ಏನಿದೆ ನಾನು ಮಾಡ್ತೀನಿ. ದ ಥರ್ಡ್ ಕ್ಯಾಟಗರಿ ಗ್ರೇಟ್ನೆಸ್ ಮೀನ್ಸ್ ಸ್ಯಾಕ್ರಿಫೈಸಿಂಗ್ ಎವ್ರಿಥಿಂಗ್. ನನ್ನನ್ನು ಸಂಪೂರ್ಣವಾಗಿ ಸಮಾಜಕ್ಕೆ ಸಮರ್ಪಣೆ ಮಾಡಿಕೊಂಡು ಬರೀ ಸಮಾಜಕ್ಕೋಸ್ಕರ ನಾನು ಬದುಕ್ತೀನಿ ಅಂತಾರಲ್ಲ, ದಟ್ ಈಸ್ ಗ್ರೇಟ್ನೆಸ್. ದಟ್ ಈಸ್ ಗ್ರೇಟ್. ದೋಸ್ ಆರ್ ಆಲ್ ದಿ ಪರ್ಸನ್ಸ್ ಕಾಲ್ಡ್ ಆಸ್ ಗ್ರೇಟ್ ಪರ್ಸನಾಲಿಟೀಸ್. ಗೌತಮ್ ಬುದ್ಧ ಇರ್ಬೋದು, ವಿವೇಕಾನಂದ ಇರ್ಬೋದು, ಬೇಕಾದಷ್ಟು ಜನ ನಾವು ಹಿಂದೆ ಬಂದಿದ್ದವರನ್ನು ನೋಡಿದ್ದೀವಿ. ಅವರು ಸರ್ವಸಂಗ ಪರಿತ್ಯಾಗಿಗಳಾಗಿ ತಮ್ಮನ್ನೆಲ್ಲ ಬಿಟ್ಟು, ಗೌತಮ್ ಬುದ್ಧ ರಾಜನ ಮಗ, ಅವ್ನಿಗೇನು ಬೇಕಾಗಿತ್ತು, ರಾಜ್ಕುಮಾರ ಎಲ್ಲ ಇತ್ತು, ಅವನಿಗೆ ಎಲ್ಲ ಬಿಟ್ಟು ಹೊರಟ ಸಮಾಜ ಸೇವೆ ಮಾಡಬೇಕು. ಅವರು ದೇ ಆರ್ ಆಲ್ ಗ್ರೇಟ್ ಪರ್ಸನಾಲಿಟೀಸ್. ಎವ್ರಿಬಡಿ ಕೆನಾಟ್ ಬಿಕಮ್ ಗ್ರೇಟ್ ಪರ್ಸನಾಲಿಟೀಸ್. ಅಟ್ ಲೀಸ್ಟ್ few of you, I hope and trust, everybody will become good, very good and excellent. And out of you, I hope and trust, some people should become great personalities of our country. Thank you so much for the opportunity. And once again, I thank our legal luminary, Sri P.R. Subramania, for calling me and giving me opportunity to share a few of my thoughts with all of you. Thank you and all the best.
Thank you, sir, for the rather thought-provoking talk. As we come to the end of this session, I deem it a privilege to propose a vote of thanks in this memorable occasion. On behalf of CMRU University School of Legal Study, attendees, if you have any queries, you can put them forth.
Morning, sir. So we were talking about administration, the role of the individuals of the legal field when it comes to administration. And specifically, while you were speaking of maladministration and those attributes, you emphasized on something that is influence, nepotism in these aspects. So on these lines, there are two terms which come into my mind, and I want to know how we as people of the legal field can distinguish when it comes to appointments in any sort of government job or any of the organs of the government. Two words are, how will you distinguish between reference and influence when it comes to appointment of individuals?
Reference.
Reference, sir, sometimes when, because a person is very good in something, one individual may refer the person to another department.
That is one way of influence.
So how will you distinguish it, sir? Is there any test which you can apply to understand how these two things can be distinguished? Because then again, when influence comes into picture, you have nepotism also which comes in. So how will you bifurcate it in a proper fashion?
You see, as I told you that nepotism is different from influence. ನೆಪೋಟಿಸಮ್ ಕನ್ನಡದಲ್ಲಿ ನಾವೇನು ಹೇಳ್ತೀವಿ ಅಂತಂತಂದರೆ, ನಮಗೆ ಬೇಕಾದವರಿಗೆ ನಾವು ಕೊಡೋದು, ನಮ್ಮ ಜಾತಿಯವನು ಅಂತ ಕೊಡೋದು, ಅಥವಾ ನನ್ನ ನೆಂಟ, ನಮ್ಮ ಸಂಬಂಧ ಅಂತಂದು ಕೊಡೋದು. ಇನ್ಫ್ಲೂಯೆನ್ಸ್ ಅಂತಂದರೆ ಇರ್ರೆಸ್ಪೆಕ್ಟಿವ್ ಆಫ್ ಆಲ್ ದೀಸ್ ಥಿಂಗ್ಸ್. ಮೇಲ್ನವ್ರು ಹೇಳಿದ್ದಾರೆ ಅಥವಾ ಮಿನಿಸ್ಟರ್ ಹೇಳಿದ್ದಾರೆ, ಅವನು ಯಾವ ಜಾತಿಯಾರಾಗಲಿ ಯಾವುದಾರಾಗಲಿ ಏನಾರು ಆಗಲಿ, ಅವನು ಏನಾರು ಆಗಿರಲಿ ಅವನಿಗೆ ಕೊಡೋದು. ಸೊ ಇಲ್ಲಿ ಏನಾಗುತ್ತೆ, ನೆಪೋಟಿಸಮ್ ಆ್ಯಂಡ್ ಇನ್ಫ್ಲೂಯೆನ್ಸ್, ಹೌ ಇಟ್ ವಿಲ್ ಬಿ ಪ್ರಾಕ್ಟೀಸ್ ಇನ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ಸ್. ಸೊ ಅಕಾರ್ಡಿಂಗ್ ಟು ಯು, ಯು ಆರ್ ಕಾನ್ಸಂಟ್ರೇಟಿಂಗ್ ಆನ್ government appointments. So the law should be in such a manner that there should not be any room for any nepotism to practice any nepotism or influence. How they will do this? To incorporate this nepotism and as well as the influence in public, for example, if online applications to be filled up, online examination has to be conducted, no interview, then to some extent transparency will come into picture. They will also do this act even at the initial stages. If they don't want anybody, online applications, how it can be rejected, they will also find out a way. And afterwards, if there is any interview, physical or that is oral interview is there, in such type of discretion can be exercised by the competent authority. So wherever you give discretion to the competent authority in appointments, in such places definitely this nepotism, influence, everything can be influenced or practiced. So therefore nowadays the government is also doing, and the examinations are also being conducted, that there is no question of oral examination so far as some of the appointments are concerned. There also, in some of the cases, now presently I am handling that case, in recently about 6 or 7 years ago or even before that, the examination for this assistant public prosecutors were conducted. And after the examination, the candidates were so powerful, they managed to get the number altered. The number which were put on the facing sheet of the answer sheets, they got it altered with the help of the public servants who were in the prosecution directorate department. So it was detected, and Upalokayukta police have investigated now. And actually, those papers were evaluated by judges. I also evaluated some of the papers. But after evaluation, the facing sheet has been altered. Signature of the judicial officer who evaluated is the same, but numbers are altered. Inside also, proportionately, the numbers have been altered. You see here, this is malpractice, malfunction. So therefore, as far as possible, it will happen, the nepotism will happen and malpractice will happen, influence will happen definitely, as long as this discretionary power is given to the authorities in appointments. So this should be evaded. That is, the people like you, by means of innovative measures, you should find out that without giving any discretion to the competent authority in appointments, only purely on merit the appointment should take place. Or else, the appointing authority, the person who handles the case should be so clean and honest, sincere, and such type of person should be selected as appointing authorities. Then only to some extent we can control this. Any other question? So we can wind up. Thank you.
On behalf of CMRU University, School of Legal Studies, and the entire fraternity, I extend my heartfelt gratitude to our esteemed speaker, Honorable Mr. Justice K.N. Phaneendra, Upalokayukta, and the state of Karnataka. Today's guest lecture on the role of public and law students in public administration has been incredibly insightful and thought-provoking. Honorable Mr. Justice K.N. Phaneendra, sir, your profound insights and eloquent analysis on the critical role of education and awareness and the active participation played in shaping effective public governance has deepened our understanding of the subject. Thank you, sir, for sharing your vast knowledge and experience with us. Your words have undoubtedly left a lasting impact on all of us and will serve as a guiding light as we navigate our academic and professional journey. I now request our Dean, Professor Dr. T.R. Subramania, to present our guest with a token of gratitude. Thank you, sir. We're deeply grateful to our Dean, Professor Dr. T.R. Subramania, for his unwavering support and inspiring words of engagement. Sir, your able guidance and vision continue to inspire us to strive for excellence. Thank you for your kindness, interest, and steadfast support. I would also like to extend our heartfelt thanks to our well-wisher, Professor Dr. V.J. Pranmeshwaran, Director, Professor, for his invaluable stewardship, vision, and commitment, which makes opportunities like this possible. A special note of gratitude goes out to our faculty coordinator, Ms. Nirmala Harish, for her valuable guidance, encouragement, and contributions that have played an integral role in the success of the event. I thank all the attendees for their patience and interactive participation in today's session. I would like to conclude by sharing a quote by Carl Sagan that resonates with the spirit of this academic pursuit. Somewhere, something incredible is awaiting to be known. Let us continue this journey of discovery with determination and curiosity. Thank you, everyone. I request the participants to fill in the feedback form. Have a great day.